Good morning, dear colleagues. We start briefing. The topic is first results of the monitoring violation of digital rights in Ukraine. Our guests are Oleksandr Burmagin, media consultant, executive director of the NGO Human Rights Platform, and Lyudmyla Opryshko, advocate, media officer of the NGO Human Rights Platform. Good afternoon, dear ladies and gentlemen. Good afternoon, friends and colleagues. We are really glad that you're attending our briefing. Today we are going to provide the results of monitoring of digital rights violation in Ukraine. We believe that this project has good prospects. Whether we like it or not, media environment becomes closer and closer to us, and we shift to digital environment. We may provide information about us, about life of the country, about many things. Even the new president says that the government will use it efficiently, so we see that there is a great future in this. And our organization put a question to ourselves whether human rights are adhered to in digital environment. This idea is not new. Last year, our organization Human Rights Platform, together with partner organizations, we created the coalition that is called For Free Internet. It was joined by such reputable organizations as International Organization Freedom House and the Center of Information on Human Rights and Laboratory of Digital Safety and Crimean Protection Group. This is a coalition of NGOs that are really powerful, who take care of the freedom of speech, and they are ready to fight for it at different levels. Last year we saw that in Ukraine, issues appeared that needed swift resolution. Last year, there were several declarations about blocking of websites. These were declarations concerning 2 decrees of the president, 2017 and 2018, one based on an NSDC decision. Many websites were blocked. Even such sites as economic news, экономические известия. So this is the media source that was never accused before that it spread some illegal information. And after this blocking, this resource stopped its work, and this is a disturbing sign. After this, there was draft law 6688 and the draft law 9275 and other drafts that raised concern and motivated us to bring attention of society to these legal ways to restrict freedom of rights on the internet. This year, we also had one survey concerning the issues of criminal punishment for the spread of information on the internet. And this was a preparatory stage to the emergence of the idea that we've started to implement recently. We understood that media environment, digital environment provides a lot of opportunities, and we should implement human rights in this area. This is the freedom of speech and education and peaceful gatherings rights. All this can be done in information sphere, especially on the internet. And internet plays a really important role in our life, and we wanted to consider whether there are violations in this area. Offline, in real daily life, we see many violations of freedom of speech, and monthly some organizations provide their reports and they make public the facts. that they recorded in offline media. But about media environment, it has its own peculiarities. It has some peculiarities in broadcasting of the information. There are some advantages, of course, but also there are some risks that it has. We decided to carry out such a monitoring, and the results of this monitoring will be made public monthly. Today we present the first month of this monitoring. This is about the violation of digital rights, and we believe that this is the rights of people in the media environment. This is a new term. It is not envisaged by any normative act, but it is popular, and often it is used by lawyers, journalists, and by those who take care of freedom of speech. This monitoring was carried out using methodology that was developed last month. And while preparing this methodology, we also cooperated with the coalition members, and we really appreciated their friendly help. And now we use this methodology, and we want to present the first results. Speaking about methodology, I would like to say several words on methodology. This monitoring is built like this. First, we monitor web resources. We search for any information connected with violations of human rights on the internet. This is the Unified Register of Court decisions, and we collected some decisions to understand whether there are some violations, and we will tell you about them. We monitor websites and websites of media organizations where there may be some information about human rights. So we collect all these messages, all these facts, and we group them according to such a thing. First, this general violations that influence on all citizens that want to get access to internet or to use its opportunities. Another group of violations connected with individual violations. These violations of rights of individuals. And my colleague Oleksandr will tell you more about these violations that we recorded during the first months. And we will be grateful for your comments, because for us, the methodology, this is a live instrument. If you see that we may improve, we will be grateful for your recommendations. And further, we are going to make this research more informative and to improve it. Thank you.
Thank you, Lyudmyla. Good morning, dear colleagues and guests. I would like to add a couple of words about this monitoring and why this survey is important. As Lyudmyla mentioned, the internet and IT development is going with a high speed and is covering more and more areas of our life, social life, economic life. More and more people start to use these technologies every day. Even more aged people get access to smartphones, different gadgets, and at the same time, a huge number of challenges appears, and in the EU, in the Council of Europe, in the US, they started to speak about such kinds of challenges and violations as electronic interferences, electronic attacks, etc. And the cyber defense budget had grown from 2 billion euros last year up to 5 billion euros this year. This is the result of all those challenges which Europe experiences today. And as of today, nobody can offer ready solutions to many challenges and problems. We only try to find ways to prevent violations in the internet area, to mitigate risks and to remove threats, to prevent threats. In Ukraine, we are trying to counteract to those challenges, to mitigate risks since 2014, because we had become the victims of hybrid war from Russian Federation, and actually we were used as experimental field for Russia. But nevertheless, as of today, we have not found any highly efficient solutions. In this situation, it is extremely important to carry out monitoring surveys, survey to understand how the state tries to regulate the internet, because this is directly related to the enjoyment of human rights. We hope that this monitoring, this survey would become the regular one, and that it will be conducted on 6 months basis, and we will add to our analytical reports also the results of our partners' analytics, which studies situation in the occupied territories. So we are prepared to systemic work and are keen to make this the large-scale and influential source of analytical information. We are ready to use this data in the dialogue with law enforcement agencies, with the parliament, with those people who are decision makers, presenting the degree of risks in the digital area, and with the purpose to point out that some bills, some draft laws or regulations are breaching the human rights. Lyudmyla described in more detail the methodology of our survey. So the first topic of our monitoring were violations of general nature, because these violations influence unlimited number of people. Those general measures are harmful for the biggest area of human rights. in Ukraine, unfortunately, during 2017 and 18, we experienced two waves of the blocking of websites. How this was done? This was done via the decrees of the president, which were enacted by which enacted the National Security and Defense Council decisions. Our partners in the coalition believe that this blocking of sites continues even today, while in some territories the websites are deblocked, in other territories they are blocked, and thus this is a continuous process. We actually, the situation persists, and in May this year, that picture remained in place. Those sites which were blocked during 2017 and 18 were blocked for 3 years. So if within 3 years nothing would change, so this would be extended. The access to those resources was limited based on partially good grounds. For example, Vkontakte, Odnoklassniki, which are purely Russian networks. And at the beginning, it was perceived as positive step, but the human rights require us to assess how this is done. And unfortunately, the way how it is done remains undemocratic in Ukraine. The mechanism which allowed us to block 240 websites, including Ukrainian resources, which is an absurd because the law which provides for the blocking of sites, it refers to the anti-national characteristic of websites. We believe that those blockings are unacceptable from the point of view of national standards, and because it is allowed upon full discretion of the power, and sometimes it's not understandable how the list of those sites that should be blocked is created. Now, in police, we have two criminal proceedings started because the law enforcement agencies failed to provide us with the answer why they have blocked two websites. So here we observe full discretion of the government authorities in blocking the websites, and sometimes it is not clear how to complain for those blockings. Violation of digital rights should be seen via the glasses of the human rights violation. The ideologies of the state may change, and having created such a stick which allows to block any website, in the future you would see the same stick in different hands of ideological people, and they will apply it in different direction. That is what is not always understood by those who protect the government, saying that government is acting correctly when applying its violent measures. Or we may understand that in some moment of time and in some moment of fight that was acceptable, that actions were acceptable, but we need to establish a working group which has to develop the response measures for such cases. So in 2019, we cannot continue with a statement that closure of those 240 websites was extremely needed. Actually, we have not developed any legislative solutions for this situation. From the Council of Europe Digital Standards point of view, this could be also seen as a violation of human rights by government authorities. The European standards suggest that the authorities have to protect internet users from any abuse of digital ITs. Thus, we can see that nothing was done in Ukraine. Having analyzed the register of criminal verdicts and found no systemic approach as to the violations of digital rights. And we do not expect for any positive movements. Blockings of sites were characterized by us as the general violation of digital rights. The second group of rights were the use of Facebook for violations of other rights like electoral rights, and because we had very passionate, very emotional presidential campaign, and many ballots were field ballots were shown on Facebook, which is a violation. And you may remember that one of the candidates had shown the field bulletin, field ballot, and he posted it on Facebook, and actually immediately the criminal case was opened. And the question arose what to do, and the enforcement bodies decided to apply Article 21010 of criminal administrative violations, administrative offenses code. Then in second round, Mr. Zelensky had done the same. Later on in May, we have discovered 7 cases of the same nature when voters on Facebook had shown their ballots, voting ballots, which is actually the same violations. Then we started to analyze the verdicts of courts as to all those claims, and we found out that the court decisions, they are very controversial and they're not proportionate. Sometimes they impose fines, sometimes they find that this was not charged as administrative violation. Some cases were denied by court, etc. So here we observe clear shortcomings in the direct duty of the state to punish for the violation of human rights. Thus, having analyzed the Facebook materials, and court decisions, we now cannot understand whether these are violations or not. You can see that one case that happened during first round of elections, it resulted in the whole flow of repetitions and followers, and although monitoring and enforcement of the electoral legislation is clear, very important, but at the same time it may result any non-response may result in very bad consequences. Political technologies very quickly use this non-action of the courts, which means that the human right to elect independent candidate independent candidates will be violated. Currently, we are at the beginning of our parliamentary campaign, and the next year we will have another local elections. So we have to prevent a situation when this technology of using pictures of field ballots on Facebook should be prevented. The second category of our monitoring is a big group of violations, violation of the freedom of expression and information via digital sources. In May, there was an attack on Vadim Komarov, a journalist and video blogger in Cherkasy. He remains injured and in the intensive care unit. Then an attack on Natalia Kamyshnikova's place of residence in Novovolynsk region. And in Odessa, unknown people had attacked local journalist and activist Svetlana Pitpala, who published posts about illegal and unlawful construction sites. Another fact, non-proportionate limitation of the freedom of speech imposed by Korostin City Council in Zhytomyr region as to the Facebook post. when journalists write emotional posts, then those people who are mentioned in those emotional posts, they file cases to court. We have included the court had recognized as not truthful the following emotional wordings offered by journalists. For example, our mayor is not a psychiatric patient. So if this not patient this is untrue statement, what does it mean? That our mayor is a psychiatric patient or what? And the court had awarded the payment of interest for violation of for moral damages. And although in the article the civic interests were raised and they in the court decision, it was not taken into account that those journalists, those MPs, they were MPs of the local council. They tried to draw attention to the public interest, and they had the right to use very strong expressions in their polemics. So payment of moral damages was awarded by court. We believe this is violation of human rights and violation of the freedom of speech.
I would like to say that we will publish this information on our site, on our Facebook pages and Facebook pages of our colleagues. We will have all the references, all additional information will be provided. There will be a full-fledged report with all the references. Also, the information about searches, taking equipment, and interviews with the employees of editorial office of finance.ua website. So all the equipment was taken away, and in May this issue remained unresolved, whether it is evidence or not, whether it should be returned. And also the decision was considered both times by one judge in Голосіївський court. So there were many procedural issues. And as of May, this issue was not resolved. Criminal cases should not block the work of websites, and equipment should be taken away only in the scope that is necessary for examination. When all equipment is taken away, we believe that this is violation in the sphere of digital rights, and we will pay attention to this. About private life and data protection, these are individual violations. There was illegal entrance to the page of Viktor Muzhenko, and he informed that there was breakage into his website, and also 2 instances of non-proportional interference in the secrecy of emails and correspondence concerning criminal cases. There was a case of fraud, and we understand that there were several calls during 1 month, and the court provides permit to seize the letters, the correspondence, to study all the phone calls and messages. And in the course of investigation, this permit may be provided to get all information about the person who is a suspect. So we recorded 8 instances of violations of individual digital rights, and on the whole 255. So 240 of general character and 15 individual, including electoral issues. And we would like to make our research systemic and comprehensive, and in May we recorded, with the help of our partners from the Platform for Free Internet, these are violations of digital rights, WhatsApp messenger problems, and also 5 organizations were referred to fraud site. And also in Instagram, also there was a problem, and there is statistics concerning this malfunctioning, and these are the results of May 2019. And starting July, we will report on June. So we have 5 minutes for Q&A session. As I understand, you do not have questions. Thank you, dear friends, for attending our event. And we will be glad to continue our work and follow these violations and analyze them. And we will work on eliminating such instances. Thank you very much.